Today, we will talk about adhesion contracts. An adhesion contract is an agreement that usually has non-negotiable terms and conditions. Generally, it's prepared by a party to a potential transaction that has the product or service sought by another party, the consumer. The former has the stronger bargaining position. The latter must accept the adhesion contract to obtain the product or service. Adhesion contracts are also known as standard, standardized, or boilerplate contracts. Adhesion contracts are often used for insurance, leases, vehicle purchases, mortgages, and other transactions where there is a high volume of customers who fit a standard form of agreement. For instance, with an insurance contract, the company and its agent have the power to draft the contract, while the potential policyholder only has the right of refusal. It is important for consumers to read an adhesion contract carefully, as all the information and rules have been written by the other party. Adhesion contracts are usually enforceable in the United States according to the Uniform Commercial Code. The UCC helps to ensure that commercial transactions take place under a similar set of laws across the country. Although the UCC is followed by most U.S. states, it has not been fully adopted by some jurisdictions such as American Samoa and Puerto Rico. Louisiana stands alone among the 50 states in adopting only parts of the UCC. The UCC has specific provisions relating to adhesion contracts for the sale or lease of goods. Contracts of adhesion are, however, subject to additional scrutiny and interpretation under state law. Adhesion contracts started to become part of the U.S. legal system only after the Harvard Law Review published an article on life insurance contracts by Edwin W. Patterson in 1919. Subsequently, most courts accepted the idea of contract adhesion, due in large part to a Supreme Court of California case that supported adhesion analysis in 1962. The specifics of the legality and enforceability of adhesion contracts have changed over time. The case law and interpretation may vary from state to state, but it is generally agreed that adhesion contracts are an efficient way to handle standardized transactions. For a contract to be treated as an adhesion contract, it must be presented as a take-it-or-leave-it deal. Adhesion contracts are subject to scrutiny that usually comes in one of two forms. 1. Reasonable expectations. Courts have traditionally used the doctrine of reasonable expectations to test whether an adhesion contract is enforceable. Whether a contract is reasonable depends on the prominence of its terms, the purpose of the terms, and the circumstances surrounding acceptance of the contract. 2. Unconscionability. The doctrine of unconscionability has also been used in contract law to challenge certain adhesion contracts. If the contract is exceptionally unfair to the signing party, it can be declared unenforceable in court. Here are 5 key takeaways. 1. Adhesion contracts are take-it-or-leave-it agreements where you must accept the contract or walk away. 2. Adhesion contracts are meant to simplify business transactions by standardizing the agreement between the supplier and the buyer. 3. To be enforceable, adhesion contracts cannot be unreasonably one-sided. 4. Courts ultimately decide what is reasonable within an adhesion contract. 5. The legal view of such contracts has evolved over time and may differ across jurisdictions. Hope this would help. Thanks for watching.